Hearing the appeal, Homes and Communities Agency, Wilmslow Limited.
Kingston.
My Lords, I appear with my learned friend Mr. Kimblin on behalf of the appellants, my learned friends Mr. Humphreys and Mr. Booth, both of Queen's Counsel, appear on behalf of the respondents. My Lords, you should have two supplementary core document bundles, 3 and 4.
Yes.
There excuse me, was perhaps a modest issue about one of the documents, the first one in core document bundle 3, that is the closing submissions of my learned friend Mr. Humphreys to the upper tribunal, but I'm told that there is no objection to your lordships having that and being referred to it in due course, and so I won't trouble with any argument about why you should do so.
I'm not sure I've got them, but I don't think we need to hold things up.
My Lord.
Okay, yes, I do have some supplementary calls.
Is this the warning of an argument about inconsistency of submissions at different stages?
No, my Lord, it's the warning, if such it be, of a position which seeks to explain why it is that the upper tribunal described its task in the way it did in paragraphs 52 to 55 of its decision. That is something we'll come to in detail in due course, but you'll have seen already, I suspect, the tribunal described the nature of the exercise in paragraphs 52 to 55 in a very particular way, splitting the issues into two particular categories. It did so, and as I said, I don't now need to trouble your lordships with it in detail, but it did so directly in response to the evidence and submissions of the parties. My Lords, there is, in addition to those
as Lord Sumption implies, we're not going to be terribly assisted by accusations of changes of position as the case proceeds for its own sake, but I can quite well see it in order to explain why something happened below. You need to, if it becomes relevant, you need to explain why. Yep, thank you.
Quite. Well, I can assure you I'm not going to trouble you with any inconsistency of submissions points, which I can appreciate.
Is there a supplementary core documents volume 4?
Yes, there is, my Lord.
I'm sure we don't have that.
That came in quite late. Came with a letter.
It contains Mr. Kimblin's note, and such it is, on the amendments to the Land Compensation Act, a better and more complete copy of Section 16 of the 1961 Act, a complete reprint of the respondent's written case because there was a typographical error in the original one, and then finally at tab 4, the Neighbourhood Planning Bill in its current form, in particular clause 27.
Well, we'll have those in due course, but
Came behind a letter of the 9th of January.
Yeah.
And may be obscured by it.
Right. Thank you, my Lord. I'm grateful. There is, in addition, a supplementary bundle of authorities with two authorities in responding to the email from the court. The first is the law report's copy of the decision of the House of Lords in Spirose.
Have we got that? Yes, I mean, that was, I think I asked for that, yes.
well, yes.
It's available now, if you'd like
Okay,
it.
well, give it to us when it comes up.
Right.
Okay.
The second authority, which might be, in a sense, more germane to have to hand sooner rather than later,
Right.
is Melwood, which the court indicated that it would be interested in.
Well, if you want to hand them up now, that's fine. If you want to hand them up when you come to them, that's also fine.
My Lords. My Lords, the parties' written cases, the statement of facts and issues contain all of the relevant material.
Yes.
When permission to appeal was granted, the panel indicated that they would wish to hear submissions on the effects of the localism bill. I'm pleased to tell you that Mr. Kimblin will follow on that matter to the extent that it's necessary, in accordance with the
Your position, I take it, is that that really isn't relevant.
No.
I think our concern, if I can speak for myself, was just to make sure that we weren't going to be saying anything which would sort of somehow prejudice or get in the way of that.
Yeah.
And maybe Mr. Kimber will be able to help us on that. But
Well,
I doubt if we're
sure.
going to want to spend a lot of time on it.
I'm sure he's looking forward to doing that in due course, so far as necessary. And as you see, I've made the immediate hospital pass about an area which I felt I'd got quite enough to deal with without needing to trespass into. So, my lords, that will be dealt with in that way. May I, before turning to the submissions that we wish to make, just do a little orientation exercise to the extent that it's necessary. Core Documents, Volume 2.
Yes. Where are we looking at?
Tab 25.
Thank you. Yes.
This plan
Yes.
conveniently overlays onto the Kingsway Business Park layout plan, the reference land in 2 plots with the dot dash line. The upper plot is plot 13, the lower is plot 14. Together they total some 10.86 hectares. It also shows hatched and at the right-hand side of the reference land, what's described as part plot X land.
Yes.
Plot X, as you can see from the plan, is a part of the Kingsway Business Park master plan, which was indicated as being appropriate for residential development. And the part plot X is the part of the reference land which falls within that area which was indicated as appropriate for residential development. Also shown...
It's shown as part plot X.
I
This is what page is this?
it's page 305, and if your lordship would look at the key in the top right-hand corner,
Part plot X land, I see, thank you.
not at all. That's the part plot X, so that's the part of the reference.
Sorry, I'm not with
Top
you.
right.
What, plot X?
Part-
Oh, I see. Oh, part plot X, yes. So plot X includes the bit which is marked plot X on the plan, plus that.
The reason for the part,
That's residential as well, is it?
well, the reason for showing it as part plot X is to indicate that that's the part of the reference land which fell within plot X of the Kingsway Business Park, where residential development was indicated in the Kingsway Business Park master plan. And that's the bit about which essentially there was the valuation argument before the tribunal, the main argument. Also relevant on the plan and of importance, you'll have seen it referred to, I think, paragraph 85 of the tribunal's decision, the nib. The nib hatched in red and effectively joining up the part plot X parts of the reference land with Buckley Hill Lane, which you can see running here on the plan with the houses fronting it. And then one final matter from the plan. You'll no doubt, my lords, have seen that the tribunal at paragraph 97 referred in support of their view that residential development was a prospect on the reference land to there having been recent residential development to the east of Buckley Hill Lane. On the bottom right-hand corner of this plan,
Yes.
you will see what looks very obviously like a modern housing estate layout. That's a part, at least, of what was being referred to.
What does the nib mean?
The nib is an area of land which...
What does the word the nib mean?
Oh, no, it has no... My lord, it has no scientific or...
I can see where it is on the plan.
Well, it's
Yes, and it was called...
old-fashioned fountain pens used to have.
I beg your pardon? I beg your pardon, my lord, I'm afraid I didn't catch that. But
Old-fashioned fountain pens.
old-fashioned fountain pens, yes, indeed.
Nibs, yes, okay.
I see none of us sports one, but my lords, the nib was important because it provided the access and it was in the ownership of a related company. The tribunal dealt with it, paragraph 85, it features in the valuation.
Right.
I'll return to it in due course if I may.
Yes, you may. Thank you.
May I, before then turning to any detailed submissions, simply present
Yes, carry on. don't worry.
present something of an overview. In this case, the upper tribunal was faced with a situation where they had to value an area of land which had the following characteristics in accordance with the evidence before them and their findings. Firstly, it had an access to the public highway via the nib independent of any KBP infrastructure or any KBP land, and there was no highway objection to that point of access.
Right.
The tribunal's decision, paragraph 67. Secondly, it was an area where similar residential development had occurred relatively recently.
Just the other side of the road.
Just the other side of the road, paragraph 97. Thirdly, it was part of an area which, although greenfield, that is, it hadn't previously been developed, had long been identified for some form of development or another. Again, paragraph 97. Fourthly, excuse me, it was within, excuse me, within the defined urban area boundary in the statutory development plan, independent of any Kingsway Park, Business Park designation, a matter the tribunal had before them in a report referred to as the Section 17 application report. Fifthly, it had what the tribunal described as extensive policy support, referring, we think, given the references in the tribunal's report, referring to a study which the council had undertaken of where there was potential for housing development, and indeed in such a study it was in a priority area. And sixthly, it had been identified as part of the housing land supply of the council and treated as a committed housing site by them. The tribunal sought to get as close to reality as possible in the rather arcane world that they were due to occupy, having regard to the law as it then stood. And, my lords, you can see that from the tribunal's decision, tab 9, in volume 1, paragraph 52. Paragraph 52, page 158.
I've been favoured with one that proceeds straight from paragraph 49 to paragraph 60.
My lord, I think that's because there's a great big quote from Waters in the decision. If your lordship would turn to the bundle page 158.
I see.
I hope.
All is clear.
I hope that might be said. Right. You can see at paragraph 52, the impulse not to move further away from reality than law compels is evident in the case it's a powerful impulse to be shared. So this is a tribunal trying to grip the reality of the position. You can see that also reflected if you jump forward to paragraph 93 on page 168. This is where the tribunal was considering what the position was with regard to development.
Thank you.
The only development that would produce an increased value on the reference land, which would not have to be discarded under the statute, would be a likely development that took no part of the other land, that is the KBP land. In other words, that would have to be development which took access from the existing Buckley Hill Lane, all part of, as it were, grappling with the reality. In those circumstances, the tribunal was faced with the acquiring authority saying, on the one hand, the scheme was cancelled on the reference land in accordance with what your lordships will have seen, the cancellation assumption. But then saying, the acquiring authority, that essentially scheme requirements, such as the requirement for a comprehensive form of development, which was essentially a scheme requirement, were to be reimposed via the operation of planning policy. And I've taken that example of the comprehensiveness aspect because it's one that the tribunal referred to themselves when they quoted the inspector at the compulsory purchase order inquiry, page 147 of volume 1, paragraph 19. Here the tribunal is quoting.
Paragraph, sorry?
It's paragraph 19
Thank
of
you.
the
Yeah, I have
tribunal's
it. Thank you. Yep.
decision, page 147.
Thank you. Yep. Yes, yes.
Here, in the recital of the history and the circumstances, the tribunal is quoting the inspector's report from the compulsory purchase order inquiry, paragraph 562. Your lordships will be able to read the whole paragraph. I won't read it all out. But in the middle, you'll see there can be no comfort that private investment would take place such as to achieve the regeneration purposes of the comprehensive KBP scheme as constituted in the NWDA's proposal. So comprehensiveness there, part of the scheme, part of what was the NWDA's proposal. And as I've said, the tribunal faced with the acquiring authority saying, on the one hand, cancellation, on the other hand, you don't escape from the clutches of the KBP scheme because the policy has this requirement for, among other things, comprehensiveness. In those circumstances, my Lord, seeking to achieve the objective of both the law and policy in terms of compensation, the upper tribunal adopted an approach which sought, we say properly, to neither diminish nor increase the value of the reference land as a consequence of the scheme. My Lords, finally, as part of an overview, our submission is that an assessment of the planning policies and the material considerations in the no-scheme world was a fact-sensitive judgment for the experienced members of the upper tribunal, not a matter for the Court of Appeal to strike what it thought was the right balance. And I've used that wording advisedly because that is what the Court of Appeal said it should do. If your Lordships would go to tab 8.
Yes.
Page 135, as part of the judgment of Lord Justice Patten. Paragraph 37 of the judgment. The real issue, therefore, in my view, is not whether the UT was correct to adopt the no KBP universe as a means of valuing the reference land free from the planning restrictions which the KBP scheme has produced, but whether the UT struck the balance between the no KBP universe and the planning actuality in the right place. That, my Lords, I respectfully submit, was the Court of Appeal entering an arena which was essentially the upper tribunal's arena, not the court's. It was not for the court to attempt to strike the balance, having to consider all of, for example, the planning evidence, the planning actuality. And here, to make it clear, there was a very great deal of it, 9 days of evidence.
So you say that's all a question of fact?
Well, it's a question of fact and judgment. Fact-finding and judgment as a consequence.
It's an evaluative decision.
Yes.
I understand that, but is that what the court are the Court of Appeal saying anything else? I grant you that the expression "struck the right balance" gives you the peg that you want.
Yes.
But what they're actually doing, rightly or wrongly, is propounding a proposition of law, isn't it?
Well, I might, if I may say so, have been willing to accept that proposition had I not found at paragraph 55 of the decision of the Court of Appeal and in the judgment of Lord Justice Sales, page 139, a judgment which indicated agreement with the approach of Lord Justice Patten. The end of paragraph 55, the last 3 lines, aside from the policy support for such a development scheme, there was little planning policy support for independent residential development, as the report in relation to the Section 17 application explains. That, my Lord, I submit, beyond a peradventure, makes clear that the court had entered the arena of considering what it thought was the planning evidence. And it supports, I respectfully submit, my view of the exercise which was being set out at the beginning of paragraph 37. And that, I submit, was wrong for the reasons I have briefly referred to.
Lord Justice Jackson was able to agree with both the judges.
He did, yes, happily, and no doubt gratefully in the circumstances here, but, my Lords. So, my Lords, that in essence is an overview of the position of what the tribunal was wrestling with, what they did, and I submit ultimately what the Court of Appeal did, which was wrong. The somewhat unusual feature, perhaps, of this case is that it arises from the fact that the Court of Appeal's decision was on a basis which neither party before the court had promoted, and it was not the subject of any substantial submissions. We've set it out in our printed case at greater length at paragraph 10. I don't repeat it, but, my lords, you will have seen already that the Court of Appeal in terms rejected the respondents' principal submissions, two principal submissions. And you can see that set out at paragraphs 38 and 47. At paragraph 38, having recited in paragraph 37 the submissions that Mr. Humphreys and I had made, starts with the words, "Neither of these arguments seems to me to be correct." And Lord Justice Platten went on to explain why. At paragraph 47, Lord Justice Sales, page 137 of the bundle, and some 5 lines up from the bottom, he says in a continuation, "Therefore I am not persuaded by Mr. Humphreys' principal submission on the appeal that once one has gone through the Section 14 exercise," and so on. So this was a situation in which the respondent's submissions didn't succeed, and neither, of course, did our own, for reasons.
Well, the then appellant, now respondent's principal submission was rejected.
Yes. Well, I've put it that.
You think that was a kind way of putting it?
Well, I hoped it was not.
No, I'm asking you about Lord Justice Sales putting it, not the way.
Yes, I do, because it's quite clear from what follows.
Yes,
Lord Justice Sales said that. Sorry.
There's another ground.
Yes, there was another ground, of course, in the Court of Appeal, ground 2, which was rejected by Lord Justice Patten, paragraphs 41 and following.
Yes, I see. And Lord Justice Sales agreed with Lord Justice Patten.
He did.
So, yes.
Yes. So that was the position.
Thank you.
My lords, before turning to what we respectfully say were the errors in the Court of Appeal's approach, I venture to set out some of the relevant principles of law. I do so with some hesitation because the principles in this area of the law are sometimes not very easily encapsulated, and there appear to be a very great many of them. So I've selected but 6 now of them. And what I was proposing to do was rather, because they are in some respects a commonplace, rather than take your lordship to the authorities in the particular paragraphs, giving references, and if it's troublesome, we'll come back to it. So the propositions, I've taken 3 from Spirose, 2 from Waters, and 1 from Melwood.
And are these set out in your case in that way?
They're not set out in the case in this way. I've attempted to summarise the case, my lord, and the law in this way, although, yes, actually, there is a paragraph in the printed case which Mr. Kimden will find the reference for, where we have set out.
Well, paragraph 11 gives 6 principles, but I suspect the principles you're going to give us now are not the same ones.
Not precisely. Not precisely, though.
What's wrong with the ones you had before, then? These are even better, aren't they?
Well, I won't say that until I see what the reaction is to.
The only reason I was asking, I won't have to write them down if they're already in your case. But
So there is only one, which is the last one, which I might invite your lordship, if not to write down, at least to mentally note. But let me see how I get on trying to go through them, if I may. The first is that the underlying principle is that fair compensation should be given to the owner whose land is taken. The aim is a fair financial equivalent. The owner is entitled to be compensated fully, but not entitled to receive more than fair compensation. Spirose, paragraph 89. Secondly, the basis of compensation is the value to the owner and not its value to the public authority. Paragraph 90 of Spirose. Thirdly, one plainly relevant element of the value to the owner is the prospect of being able to exploit, or, if you prefer, develop the property. Paragraph 92 of Spirose. Fourthly, in applying the disregards, It's for the tribunal to find, as a matter of fact, what is the scheme. Waters, paragraph 61. Fifthly, when in doubt, a scheme should be identified in a narrower rather than broader way. Waters, paragraph 63. And then one which does not appear in the printed case and responds to the court's indication that it would be interested in Melwood, the final one, there is no basis for suggesting that the no scheme rule has nothing to do with the planning assumptions. And I base that on Melwood, page 434, letters C to E, though I make my confession that the wording I've adopted is shamelessly taken from the decision of the Court of Appeal in Spirose and the judgment of Lord Carnwath in that court.
Well, that's rather a shaky authority, isn't it?
Well, on that point, not at all. Since when...
So this says that however wrong Lord Carnwath was on the other points.
well,
fair enough. Let's have a look at it.
I'm tempted to say that he's about to be proved right by, or has been proved right by Parliament in relation to the other point. But that's an arena which I've said I won't enter, and Mr. Kimblin can enter the lists on. For the moment, the way in which I've described the point, my point 6, was the way in which my Lord described the position when inviting, I think, Mr. Barnes, or commenting on Mr. Barnes not pursuing the point. I think it's paragraph 23 or 24.
Anyway, I mean, the point, I did refer you to Melwood, which seemed to be relevant, and you're going to take us to it, no doubt.
Yeah, in due course. But those 6 propositions, my Lords, I submit are there and stand as a good framework for the matters which we must discuss. So, my Lords, then the issues in the case before the upper tribunal, there was only one issue in this case. If your Lordships will take up the tribunal's decision at tab 9 and go to paragraph 33.
Yes.
Page 151. And the tribunal, unless your Lordships wish me to, I wasn't going to read it. The issue there set out, you can see in that regard, the evidence and arguments whether the land enjoyed any hope value. That was the issue the tribunal had to deal with. That was an issue which, before the Court of Appeal, the respondents agreed appropriately characterised, indeed, what the tribunal had to deal with. It's set out in the appellant's skeleton argument in the Court of Appeal. I don't need at this stage to turn your Lordships to it, but that's at tab 11, paragraph 15, the respondents agree. The tribunal went on, as I've noted already in our earlier exchange, to deal with the nature of the exercise which flowed from that issue, paragraph 52, page 158. And as I shall comment later on, these paragraphs 52 to 55 are of particular importance, because here the tribunal set out its approach to the submissions and evidence that it had received, responding to the closing submissions which had been made by the acquiring authority, and responding in a way in these paragraphs 52 to 55 which has not been subject to any criticism. And, my Lords, it might at least justify the fact that we've printed them and put them in just to turn up the closing submissions in order that you can see why we were anxious that you should be aware of what
I think
the
probably
tribunal...
the best way of dealing with this, because it is a somewhat marginal issue in terms of what you precisely said, is simply give us the reference. Unless you,
Yes, I could do that. The closing...
Unless it's important. precisely what you said, but
May I give you, it's not actually precisely important. What's important is the number of times that it was said and the robustness with which the respondents asserted their position with regard to independent development and the language used. So if I may, I'll provide two reference points. The first is in Volume 3, Tab 1, paragraphs 7 and 8.
yeah. Hit page?
8.
8, thank you. Yes.
You'll see the submissions, the hope that planning permission might be granted on the reference lands for some form of, note, independent development, i.e. development that does not derive its value from the scheme, is not therefore synonymous. Much the same point arising from paragraph 8 at the bottom of the page, the reference to it. The only other point of reference would start at paragraph 47 on page 22 of the bundle.
Yeah.
And you can see in paragraph 47, second and third line, planning permission would not have been granted for independent residential development. And then from 48 onwards, and I may say from 48 onwards in a series of references that continues throughout the submissions through to paragraph 125, repeated references to independent development. And it's for that reason that you find the tribunal at paragraph 55
Yep.
Independent is put in inverted commas as to illustrate what we're looking
Yeah, it is. Find the tribunal at paragraph 55 addressing the matter in the way that it did. The independent development being referred to by the tribunal there is the development with access from Buckley Hill Lane. And that's exactly responding to the submissions that were being made. Ultimately, at least before the tribunal, and indeed before the Court of Appeal, there was very little issue as between the appellants and the respondents as to the law and the way it should be applied. The issue was, and I respectfully submit remains, simply how properly to interpret this tribunal's decision. For reasons which I shall make clear at a later stage, that really is the issue. Not did they go wrong in law. My Lords, before I turn to the criticisms of the Court of Appeal's approach, and in support of the submission which I've just made, there are a series of matters where it's possible to see that the parties agreed about the legal position, and not only that, the respondents agreed that the upper tribunal got the law right in the way in which it expressed it in the early parts of its decision. In order to deal with that, I make the following points. One, I've referred to already. It's agreed by the respondents that the upper tribunal correctly characterised the issue before it. That's tab 11, their submissions at paragraph 15. Secondly, the respondents agreed that the upper tribunal rightly identified the necessity of reaching conclusions on planning issues before turning to consider matters of valuation. And if your lordships have it, it's in Core Documents, Volume 2, and at tab 11. Excuse me, paragraph 17 on page 198.
Thank you.
You can see my learned friend's skeleton argument in so stating the tribunal rightly identified.
Thank you.
Thirdly, the tribunal, it was agreed, correctly and clearly identified the importance of not eliding the stages of identifying the planning status and then seeking to value on that basis applying the disregards to the result. Same paragraph of my learned friend's closing submissions, paragraph 18 at the bottom of page 198 on to page 199. That's the skeleton argument, yes. I beg your pardon. It is, I beg your pardon, there's a skeleton argument in the Court of Appeal. Paragraphs 18 and 19. The cross-reference, which is an important one, to the tribunal's decision at paragraph 46 on page 155 in core document bundle 1. This is the tribunal, paragraph 46. The claimants can fairly claim the support of paragraphs 24 to 31 of Newell. That's the upper tribunal's decision in support of the submission that the present case regarded to be had to the authorities' KBP proposal at the stage of considering the planning assumptions to be made. Don't think that's contested. We agree the assumption required must be taken as far but no further. And then this final sentence, it's also important not to elide the stages of first identifying the planning status and then, when seeking to value on that basis, applying the disregards to the result. And the
I'm not sure I understand that. I mean, there seems to be a sort of point about having a two-stage process, and the implication seems to be that the two stages are sort of somehow completely separate. Whereas, in fact, what the tribunal go on to do is, when they get to the sort of disregard stage, is to say, well, actually, that is also relevant to what the planning potential is, and indeed that's the basis of their decision. As far as I can see, there's nothing wrong in that. I mean, what's the point about this stepped approach?
Well, it's my learned friend's point, if I may say so. I merely draw attention to the fact that he was pointing out that the tribunal were themselves cognizant of the need to make sure.
But what are you saying about it then?
What I say,
he seems to be using it to say that the tribunal got it all wrong.
Well, he does, but he does that by, if I may say so, relatively ferociously misconstruing the tribunal's decision, because the way the tribunal constructed their response was to deal with the two situations in paragraphs 52 to 55. They dealt, first of all, may I turn to it now? It jumps several stages in my argument. But
I don't want to take you out of line, but it's just because you were raising the point and I wanted to see where it's going, but by all means come to it at the convenient
in that case, I will. It is because it's an important point about how the tribunal proceeded. But the issue here was that it was the respondent's case that these two stages ought not to be elided. The tribunal said we agree, but as we shall see in just a few minutes, it's the respondent's case that the tribunal, having carefully set out all of the law, and faultlessly, as we'll see from the respondent's point of view, said what they thought it was, then apparently abandoned it.
What is your position?
That they did not...
On the question whether the two stages ought to be elided, because we're not actually dealing with rules of law here, we're dealing with tools for assessing an essentially factual point. Why shouldn't they be elided? Maybe you don't think they should.
No. Well, in this sense, they shouldn't. That as has been pointed out elsewhere, and I think again in the Court of Appeal in Spiro, is the Act has distinctions drawn between, as it were, the valuation stages, the disregard, sections 6 to 9, and the planning assumption stages, sections 14 to 17. That doesn't mean that there is no overlap, but it does mean that both require consideration. And at risk of repeating myself, I will come to it later, but what the tribunal did here, entirely logically in the light of the issues that they got in paragraphs 52 to 55, was to say, well, in particular, the second scenario, what do the disregards require? And in considering the disregards, they were considering also the scheme. And they said, well, the only scheme which would not have to ultimately be disregarded if it produced value is the Buckley Hill Lane access scheme. And they then reach, in the context of having formed that view, they then reach a planning judgment as to the arguments, and this is paragraphs 93 through to 98. Reviewing the planning evidence, they then reach a conclusion as to the planning probabilities on that issue.
So, I mean, you accept that the valuation stage can include planning judgments.
Oh, of course.
And the fact that you've been through an earlier stage of looking at planning assumptions under Section 14 doesn't preclude you then looking at the matter broadly at the valuation stage.
That's correct, if only because in terms of valuation, one's got to decide what the scheme is, the value, any value from which is being disregarded.
I mean, in this case, Section 14 didn't get you anywhere, did it? Because if you asked what planning permission you would have got if you only on the cancellation assumption, you didn't get anywhere because you came up against your policies about the roundabout. And so actually one could almost put that on one side and go straight on to the sort of no scheme Section 6 exercise.
Precisely. And then, but in dealing with the tribunal dealt with the no scheme situation in the context of the disregards. What ultimately I respectfully submit my learned friend doesn't like is that this decision wasn't boxed up or chopped up in a particular way into neat sections. Whereas I respectfully submit what the tribunal did, and did very carefully and obviously, was to respond to the evidence and the issues that had been put to it in a way that best reflected those evidence and issues.
I mean, on the face of it, as you point out, they start out by saying there's one issue, and that's value.
Yeah, hope value.
But it's hope value, isn't it?
Exactly.
Yeah.
Is there anything about hope value in the assumptions sections?
No, because
The assumptions are about planning permission that would be granted, aren't they?
Well, the assumption section here, the cancellation assumption consideration dealt just with scenario 1, the paragraph 53 in the tribunal determination terms, just with the paragraph 53. That left them, having dealt with the cancellation assumption, as my Lord Carnwath says, left them then to deal with, well, what do we do about this other situation, this other independent development situation, which the parties have devoted so much evidence, submission and time to? Well, and I interpolate here, the tribunal effectively saying that's most conveniently dealt with when we deal with the disregards in order that we don't go through an exercise which is a complete waste of time. And so they roll through the disregards, end up at paragraph 93 saying, well, the only thing that's going to get anybody any value here is a scheme which is independent of the scheme, and having decided in their terms what was a no-scheme world. They then go on from paragraph 93 to say, well, what's the planning case there? What's the evidence there? They review it. They don't, of course, recite it all for the benefit of either, if I may respectfully say so, Lord Justice Sales or anybody else. They review it and summarise it and reach conclusions. Conclusions which I submit ought not to be interfered with, short of what I'll come to in due course, some very obvious error in their approach as an expert tribunal.
So on your case, what is the point of law of general public importance in this appeal?
Is to ensure that the Court of Appeal's judgment doesn't stand in terms of a proper approach to valuation and the assessment of compensation. That's the point of law.
You say ultimately the upper tribunal, however you analyse it, approached this in an utterly orthodox and completely appropriate way.
Yes. And the reason, I do, if it's in any way tedious, you'll forgive me, but the reason I'm at pains to point out the way in which my learned friend commended the tribunal's approach is that nobody was saying to the Court of Appeal, look, in the early sections of this decision, these people simply got it wrong, so that when they came to make the actual decision, they were using the wrong legal framework. That wasn't being said.
I understand.
I understand that. Just a moment.
Well, it wouldn't be the first time that somebody has adopted a different attitude in this court from what they adopted below, and often with success. So,
Yes.
But I take your point.
I'm perfectly happy to deal, if my learned friend changes his position about the tribunal's approach, to deal with it in due course. But for the present, may I just pick up one other reference which will conveniently summarise the way in which the respondents put their case to the Court of Appeal as to whether this tribunal understood the law correctly. And this is taken from the Respondent Skeleton Argument, Volume 2 of the core documents. Page 200.
Thank you. Tab 11, page 200.
Yeah. Paragraph 24.
Yeah, so the approach they intended to adopt.
I beg pardon?
The approach it intended to adopt.
That it intended to adopt. So it was wholly consistent, both with case law and the approach commended, and so on. So, and as I've indicated, no criticism of paragraphs 52 to 55, and the way in which the tribunal characterised the issue, and therefore, my lords, in terms of the submissions being made to your lordships here, and for this you need my learned friend's written case, tab 6.
Thank you.
Tab 6, page 78.
Thank you.
And paragraph 55, where it said, thus it's clear that in its application of the valuation disregards, the upper tribunal introduced concepts of a no KBP universe and a no KBP world as a basis for revisiting and revising the prospects of this hypothetical permission. This led the upper tribunal to, and so on. My lords, I respectfully submit that that is both wrong and, in an appropriate sense, I hope, unfair. What the tribunal was doing in the part of its decision where it was dealing with the disregards was no more than reflect the approach which it had presaged in paragraphs 52 to 55, where it had referred to independent development, referred to these concepts of the no KBP universe. It did not introduce them effectively. The submissions of the parties and the evidence introduced them for the reasons that I've indicated. It follows, my lords, as I've indicated a little earlier, that the respondent's position in the Court of Appeal was necessarily, therefore, that the tribunal had correctly identified all the relevant legal principles and the proper approach to the decision and carefully set them out. But within a few paragraphs of carefully and fully setting them out, then abandoned them, and abandoned them not just in relation to marginal matters, but something which the tribunal, paragraph 46, had described as an important consideration. My lords, may I move then from that background to what we say are the errors in the Court of Appeal's reasoning. I do say against the background of the tribunal having, and for this you need tab 9, and page 153.
Right, thank you. Paragraph.
Paragraph 41.
Thank you. Yep.
The tribunal, having set out the position with regard to the cancellation assumption, pointed out at the end of the paragraph that Fletcher Estates left open the question of how much of the scheme should be assumed to be cancelled, and then in the succeeding paragraphs over the page, indicating that an answer was provided by the tribunal decision in Thomas Newell, and then going through that, the succeeding paragraphs, which I don't need to go through but simply draw attention to, in the succeeding paragraphs over the page dealing with Sparrows, the cancellation assumption, paragraph 45, and waters culminating in that paragraph which I've already referred to, paragraph 46. So, my lords, against that background of what the tribunal carefully set out, and which one can be assured, of course, that the Court of Appeal would have carefully read, we make the following submissions about the Court of Appeal's approach. Firstly, it is contrary to the approach of the House of Lords in Fletcher Estates. The reason for that, if your lordships have, excuse me, the Legal Authorities, Volume 1,
Yep.
tab 11, I think I need only say about the facts that this was a road scheme case. If your lordships would go, bundle page 542, and in the report, page 324.
Yep.
This is the speech of Lord Hope.
Yep.
And on that page, just below letter D,
Yep.
the paragraph through to just above letter F.
So which page again?
542 at the
Bundle page 542.
542, thank you.
So it's the question down to 1346.
The question which the local planning authority,
Down to
down to the
1340.
second sentence that starts, the question was whether reasons existed for the refusal of the
I see.
Planning Commission, quite independent of any scheme for the acquisition of the land for use for the purpose of the proposed bypass. My lords, the Court of Appeal's decision, I respectfully submit, does not respect that approach.
Yes, I see.
Secondly, there is, so far as we're aware, and I say it with some hesitation here, no authority to support the proposition that planning policies which may be used to support a scheme, but which have an entirely independent life in the development plan, should be ignored when assessing the prospects of planning permission being granted for any particular development. The position may be different for policies which are scheme-related.
Yeah.
And that's an important distinction here, because clearly the tribunal here was dealing with the no-scheme world. Whether there are policies which are scheme-related and the extent to which they are scheme-related is quintessentially a matter of judgment for the upper tribunal. Next, the court's approach, that is the Court of Appeal's approach, effectively looks back from the valuation date and attempts exactly the sort of speculation which was counselled against in Fletcher Estates. If your lordships would turn just to the previous page of Lord Hope's speech, and that's bundle page 541, report page 323.
Yep. Letter.
D,
Yep.
just above letter D, it is one thing to examine these factors on the assumption that the proposal has been cancelled on the relevant date in the light of existing circumstances. It's quite another to look back into the past and to try to reconstruct the planning history of the area on the assumption that the proposal had never come into existence at all. The further back in time one goes, the more likely it is that one assumption as to what would have happened must follow on another, and the more difficult it's likely to be to reach a conclusion in which anybody can have confidence. Here, the Court of Appeal's approach, with its excision, effectively, of policy EC6, invites just that sort of approach. One must look back, effectively, to see what the position would have been without such a policy in play, an exercise which we submit is wrong as a matter of law. Next, as the upper tribunal in this instance pointed out, Fletcher Estates left open the question of how much of the scheme should be assumed to be cancelled. The tribunal answered that question by looking at the upper tribunal decision in Thomas Newell, which your lordships have in the bundle. I don't need to refer to it. But in essence there, the conclusion was, and it's a conclusion which the tribunal here endorsed, that it was wrong to assume that the whole scheme was cancelled leaving it necessarily as a question of fact for the upper tribunal to determine as to what was the scheme. And that I submit based on, and it is the upper tribunal, it's not any other court, based on that decision was a proper approach and reflects the approach in Fletcher Estates. Next, the underlying planning policy is not necessarily to be equated with the CPO scheme, and there is no basis in principle for treating it as such. That would be particularly so in the case of a scheme such as an inner city regeneration scheme. A CPA may be required to assemble the land. Regeneration proposed may feature in the development plan with its own planning justification, no doubt supported by CPA powers. But in such circumstances, the development plan is not the scheme, and for the same reason, neither is any specific policy. What that leaves you with, of course, is an exercise for the decision maker, for the fact planning judgment decision maker, as to how to approach the policies in a particular case. Then the consequence is that in a no-scheme world, which is the world the tribunal was dealing with ultimately here, it's a matter of judgment for the tribunal as to which development plan policies are relevant in the particular circumstances of the case and what weight they might be given. Care may be required in deciding what weight to give to policies so as to ensure that one doesn't, in that exercise, effectively re-erect a scheme world. So in the example I gave earlier, you need to be careful here, and the tribunal no doubt were, in looking at the requirements of EC6 to say, well, to what extent is this policy simply a reflection of the CPO scheme with its requirements expressed in different ways? But that, my lords, I say respectfully, is a matter which need not and should not trouble an appellate court, short of some very obvious error of law. And then finally, as to an omission in the way in which the Court of Appeal approached the matter, we submit no principle of law that prevents consideration of the no scheme rule when considering planning assumptions. Indeed, it's, I would submit, necessary to do so. So, my lords, those areas we draw attention to, I've indicated already that the Court of Appeal's approach in this instance, we submit, substitutes its own judgment on matters which were essentially for the tribunals, those paragraphs 37 and 55 in the Court of Appeal's judgment. I don't need to repeat those matters and don't do so. What is appropriate in that context is then just to look at the approach which the upper tribunal took. Page 168 in volume 1 at tab 9. And starting at paragraph 93.
Yes.
Where you can see what the tribunal did was to, first of all, in pursuit of some sort of reality in this exercise, look for a form of development which would not be related to the other land. And as they put it at the end of paragraph 93, in other words, that would have to be development which took its access from the existing Buckley Hill Lane. And what follows then is a review, paragraph 94 and following, a review of the evidence in the light of the tribunal's view as to what was the scheme. And as I said earlier, although the respondents may not like the way in which the tribunal did it, the way in which they divided up their decision, that is nothing to the point. As far as the Court of Appeal is concerned...
the key is paragraph 96, where they consider the weight to be given to policy EC6 in the no-scheme world.
Yes.
As you would say, is a question of planning judgment, really, as to what weight to give it.
Precisely. And one may not like it,
Yeah.
but that's nothing to the point. My Lords, as far as the Court of Appeal was concerned, the Court does not appear to have been, and I say it with very great respect, bear in mind the constitution of the Court, but it doesn't appear to have been cognizant of the fact that the development plan is a document which has to be read as a whole. And for that proposition, I rely on a decision of the then Mr. Justice Sullivan, which is in the Legal Authorities, Volume 2.
Yes, exactly. Just for everything. Like any document.
At tab 19.
Yeah, I mean, this is a proposition which applies to any document that ever existed. Needs to be read as a whole.
I'm
But anyway.
heartened to hear your Lordship say it for the number of times that I remind people about it. But this decision at tab 19, page 748,
Yep.
as it happened, it's the same business park development
Right.
that we're concerned with here. There had been an earlier...
This wasn't referred to in the Court of Appeal, I get the impression from your... Because the point being run by the Court of Appeal was not a point that was raised.
No, if
Understand.
anyone had asked, my lords, we were ready and more or less able. It was in the bundle, I'm told.
Right.
But the
But
point...
so you were ready and willing, but not able.
Well,
Anyway, which paragraph?
let me take you to
Willing and able, but not...
paragraph 42 on page 757.
Yep.
Paragraph 42 sets out...
It wasn't a point you took after you read the draft judgment before it was actually handed down.
There's a fairly strong discouraging...
Well, I think if we had written in the terms which we were inclined to say when we saw the draft judgment, we would not have been altogether well received, I think. But paragraph 40, paragraph 42.
I give the Court of Appeal an opportunity to improve their reasons when you've lost anyway.
My Lord, perish the thought that would have crossed my mind, but
It wouldn't have been discreditable if it had.
no, of course. Paragraph 42 sets out Mr. John Howells of Queen's Counsel
Yes.
submission, and you can see what he was arguing about
Yes.
The criteria.
Yes.
Ground 2 then
Yep.
is introduced.
Yep.
And at paragraph 47, the learned judge, having quoted section 54A of the 1990 Act and section 70, said, in my judgment, a similar approach should be applied under section 54A. Local planning authorities should have regard to the provisions of the plan as a whole, that's to say all the provisions relevant to the application under consideration for the purpose of deciding and so on. And then just a little further on over the page, paragraph 49, perhaps I could just invite you to read the beginning of paragraph 49, the untenable proposition. And you might note for good measure paragraph 51 and the judge's view, having noted the submission about...
So it's a slightly different point from the one I was putting to. Thank you.
Yes. Then at the bottom of that same page, 54, no complaint apart from one criteria. 55, it could not sensibly be concluded. Well, all of that is very, very not...
But the fact that you don't tick every box doesn't mean you don't pass the exam.
Exactly. And here, it was just a bit more serious because it wasn't just policy EC6 which was in play and which the tribunal would have been aware of, albeit the Court of Appeal doesn't appear to have been. There were other policies in play which were directly relevant, one of which I identified in my attempt at a little summary at the beginning, one of which your lordships can see if you take up core document bundle 2. and tab 15, at page 241, this is what was referred to as the Section 17 report. It was a report which would have gone to committee if the application had not been withdrawn. And as you've seen from those paragraphs 93 and following of the Tribunal's decision, much relied on by the respondents in terms of what they said the planning position was. Now, I use it simply to draw your attention to the fact that if you go in the report to bundle page 260.
Yes.
Where in the report the officer who wrote this report, section 12, planning policy position,
Yes.
12.1.
Yes.
Within 12.1 there are numbers 1 and 2. Number 2, you can see the second sentence, reference to EC6 being cancelled. That's not relevant for these purposes here. But the land would still have been included within the defined urban area because policy EC6 does not confirm the extent of the defined urban area. This is defined by a separate UDP policy, EN1. And that's of obvious importance and would have no doubt been noted by the tribunal because to be within the defined urban area, a significant matter in terms of the acceptability or otherwise of development. That, I may say, just with a slight diversion, going back to page 254, that was not the position of the acquiring authority. You can see from the bottom of page 254, paragraph 925, they were dealing with housing only,
Yes.
without policy EC6. They said, second bullet point, contrary to H3A, it would not be within the defined urban area. The council officer noted, it's the council's view were policy EC6 to have been cancelled for the purpose of the application, the land would have been unallocated, but it would still fall within the defined urban area. So there's an example of another relevant development plan policy which would...
Where do we have the policy which says what happens in a defined urban area or why that matters?
You don't, because we didn't put in the whole of the unitary development plan.
But the assumption you say is that if it's in the defined urban area, then what?
Well, it's in other words, not in the countryside and was within an area where you would expect development ordinarily to be
There's no,
focused
in principle, objection to development.
Well, for good measure, and I'm conscious that your lordships are not, as it were, the planning panel, but for good measure, we had drawn attention to tab 31 of volume 2. A study which had been produced by the council, page 354, called the Urban Potential Study. And this was a study which set out to do just, I suppose, what it implies, identify potential housing sites. And it did so by reference to a methodology, page 358, top of page 358, which included identifying priority areas. Those priority areas were identified, paragraph 2.5 on page 358, by, for example, looking for areas close to key public transport interchanges within 800 metres. Was there a station? And you can see penultimate line of 25 Milne Row. So,
yes, but I mean, you're there inviting us to become planners. I mean, I was making a rather simpler point. The report you referred us to, the writer seems to have thought it significant that although one got rid of EC6, it would still be within, quotes, the defined urban area.
yes.
And I was assuming that one might find in somewhere in his report why he thought that was a significant fact, but you don't, you say...
I think he probably assumed that anyone reading the report would know or would be able to work out that if you defined an area of land as being within the urban area, it might be better placed to obtain planning permission for development than land which was outside the urban area. But I use that simply as an example of another aspect of the development plan and another indication of why you can't, I respectfully submit, chop it up. My Lords, in summary, therefore, the Court of Appeal's approach we submit in conflict with Fletcher Estates fails to have regard to the statutory framework as to what is the development plan, wrongly equates the scheme as being the equivalent of policy EC6 in all respects. For those reasons, we submit was wrong as a matter of law. I've indicated already that it may be that the Court's view of the matter was fuelled by its approach to what it thought its task was in terms of a review of the planning evidence and the facts. I've given you the references to those matters already, paragraphs 37 and 55. I don't repeat them and don't repeat the submissions that I've made with regard to them. My Lords, I was proposing then to move to a consideration of what I might describe as the respondent's main case, that is, not the Court of Appeal's approach, but their approach they advance as their approach one in their written case. But before I do that, I wonder if I might venture to set out some principles which ought to apply to the approach to upper tribunal or tribunals of this kind's decisions. I express them relatively, I hope, briefly, and I hope in a non-controversial way. The first one is this, that the upper tribunal is an expert tribunal. The members here were very experienced. The Court's approach to interpretation should be informed by the view of the House in AH and others, and in particular the views of Lady Hale and Lord Brown. Now, I take your lordships to that authority. It's in...
Well, we know it quite well, I think. I mean, I don't know whether, speaking for myself, it's simply saying that you respect a specialist tribunal.
Slightly more. Well,
all right, well, then let me stop.
I'm not anxious to take time with it if it's regarded as a commonplace. But, for example, Lord Brown at paragraph 43.
Which page are we on?
Page 823, tab 22.
Sorry, which tab is it?
Tab 22.
Yes, as you say, as Lord Conley says, you can take it very quickly. Yeah.
It's paragraph 43. And this was a circumstance in which, as Baroness Hale had indicated, the tribunal's determination could have been clearer. Respectfully suggest valuably illuminate the correct approach. Question of undue harshness, focusing on a series of what plainly would have been errors of approach. I too conclude, however, that so expert and experienced a tribunal cannot readily be supposed to have committed any of these errors sought to be inferred from its sometimes infelicitous drafting. And that is the simple point.
This is all example of the difficult balance sometimes to tread between, on the one hand, performing the proper appellate function and making sure that reasons are good and clear to the extent of being able to uphold a decision, while on the other hand not being too rigorous and unrealistically strict about how they express themselves. That's just familiar territory in any appellate court.
I don't read it or even want you to turn to it. Paragraph 30 of Lady Hale's judgment is the paragraph which I suspect is most often quoted and with which, no doubt, bearing in mind your lordship's workload, you are more than familiar with. Secondly, the one we've referred to already, the decision is to be read as a whole in a fair way, with regard always to the context in which a particular matter is being addressed. Thirdly, the upper tribunal is not writing an examination paper. It's writing in the context of submissions made to it. There is no pro forma for such a decision. Its content and form are necessarily shaped by the need to deal with the submissions made and what the tribunal considers as an appropriate way of doing so. Fifthly, the mere absence of a reference to any particular matter does not mean that it has been ignored or forgotten, as long as it's clear that regard has been had to the relevant principles and statutory provisions and policies. The absence of a specific reference to a particular matter should not be regarded as material. Fifthly, where the upper tribunal says that it has had regard to a particular matter or adopted an approach consistent with relevant legal principles, it should be assumed, unless the contrary is clearly demonstrated, that it has done what it has said it would do and not, just a few paragraphs later, forgotten it all. And then finally, absent irrationality, matters of judgment, what evidence to accept or not, are matters, and matters of weight, are matters for the upper tribunal. My Lords, I turn then to what we say are the errors in the respondent's case. And I deal, first of all, with the suggestion made in the respondent's written case that their so-called second approach was the approach which was ultimately adopted by the tribunal and which we sought to unsuccessfully defend in the Court of Appeal. That's not correct. It has always been our case, and we think it was always the upper tribunal's position to make its decision in accordance with the legal principles that it set out and that we have earlier looked at. And unless your lordships are persuaded by some very clear and obvious error that it didn't do so, that's the basis upon which we should proceed. It follows that if that is correct, the tribunal followed what my learned friend calls the first approach, and its decision should be regarded as unimpeachable. I've noted in the submissions I made a few moments ago that the tribunal is not following some sort of mantra or pro forma, and noted the extent to which my learned friend draws attention to what he calls a stepped approach. My Lords, we respectfully submit that it is entirely inappropriate to attempt to squeeze a particular tribunal's decision into a particular form or shape because it happens to suit a particular way of thinking. The tribunal was entitled to shape its decision in accordance with the submissions made to it, and here I submit very obviously did so. Against that background, and ready to be interrupted at any stage and told that it is not necessary, may I briefly turn through the tribunal's decision?
Well, the only reason it may not be necessary, are we going to turn to the upper tribunal's decision?
Yes.
Yes, I mean, we have read that, and you've been through it to some extent. What are the points you want to make about it? Just
Simply about the structure of it, the way in which the tribunal approached, for example.
Is it fair to say that this is something of a dog that doesn't bark in the night? You're going through it to show there's nothing there that can be criticised?
No, it's not quite the curious incident of the dog that barked in the night, but it
Didn't bark in the night.
Didn't bark, I beg your pardon. It's probably more to do with showing how unfair it is to characterise this tribunal as having gone wrong.
Would it be better to listen to the respondent to explain how they've gone wrong for you then to pick up what he says?
Yes.
Would that
I'm
be
very happy to do that.
I think if that's all right, that I think would be a better way to proceed.
More than content.
And if it ends up being unfair on the respondent for some reason, he can come back briefly and then you can reply. But I think that's probably a better way of dealing with it.
My Lords, in that event and subject to any...
Unless anyone feels... No, that's fine.
Those are my submissions.
Thank you very much.
Are we going to, sorry, you were going to let us see Melwood at some point, or is that, I mean, it would be just quite useful to have it. I mean, we don't need, I think the only relevance of it is it shows the point guard principle being used to reassess planning assumptions.
Yeah, yes, it does.
That
And
may not be controversial.
if your Lordships haven't got it, may I
But
ask?
it hasn't been circulated, and also I think it'd be useful to have the law reports version of Spiros.
It's on its way now.
Thank you. But I mean, there's no need to go to it if you don't want to.
No, I don't need to go through it in any detail, but perhaps just draw attention to the parts which seem most relevant in the light of the way the case is put. In the supplementary bundle, which order are they? Sorry. Your Lordship should be receiving a supplementary authorities bundle.
Yes, we got supplementary authorities, yes, we, thank
And
you.
the second one in the bound volume is Melwood.
Yes,
Page 40, behind page 40.
and the passage that Lord Conmouth was asking you to look at, where is that?
Page 434.
Thank you. Page 4.
434, just
I
above.
think I see it in the hard typing in the middle of the page. Yes, thank you.
Yeah.
So it's page 45, is it, or page 46 of the bundle we've got? We have it in a slightly user-unfriendly way if we're going to take it to 434.
Inconvenient for the way I've marked it up, which is marked
Sorry,
up in the
where would you
literal
want us to
law
look?
report. Well, let me just identify it.
434
in the-
starts on 45.
Yes, if you lordships go to the next paragraph on page 45 of the bundle that you've got, just about halfway down the paragraph.
The paragraph begins their lordships.
Yes.
Yes.
Just about halfway through the paragraph.
Yep.
There's a sentence starting under the principle in point good
Yes.
quarrying. Yes. And that paragraph through to hold otherwise in this case would enable the acquiring authority to inflict by its project the same injustice
Yes, I
upon
see.
remove.
I see. So it's the first 5 lines of the next page as well.
Yes.
Yes, and the point there is that in the no-scheme world, they would have got a more valuable permission,
They would.
and they were entitled to the benefit of that.
Precisely. But
Compensation.
So this was a question
Well,
of the scheme devaluing rather than increasing the value
it
of the
is,
property. Okay.
and as was put in typically pithy fashion, the point guard operates also in reverse.
Yes.
That principle, in their lordship's opinion, operates also in reverse. In other words, you don't get increased value, but equally you don't get devalued. That's the point. That's the authority, my lord. Those are our
Good.
submissions on that aspect.
Good.
Mr. Kimblin is ready to spring from the trap to tell you all about the new law, if you'd like it at this stage.
I think fairly simply, as Lord Conworth says, that the purpose is really to make sure that we don't say anything which is going to confuse or run counter to the existing law. So it's pretty short, I think.
Yes, since the gestation period has been so very long, it would be a pity to upset anything in the new law, if I may say so.
Thank you very much.
Thank you.
Thank you very much for your submissions.
My Lord, just before turning to what's been described as the new law, just to assist on the question of the defined urban area, just for my Lord's note, for documents volume 2, tab 12,
Yes.
page 221, one there has the excitement of EN1, which tells us that the defined urban area,
Yes.
future development on sites, etc., not allocated, will normally be expected to locate.
Well, that's very clear. Thank you.
So far as new law is concerned, Mr. Kingston's passed this point to the basis that is wholly irrelevant to the issues. There are two areas to touch upon. Firstly, the amendments pursuant to the Localism Act 2011, and there is a bill presently before the House of Lords, the Neighbourhood Planning Bill, which is also dealing with this area.
Thank you.
Does this all go back to the report, the Law Commission's report?
2002,
Yes, I mean, I've rather lost track of where we got to on all this.
Law Commission Report 165 for those then familiar with it, yes. And what I propose to do is to flag, firstly, that there are two helpful notes if you want to go to them in due course. The respondents have helpfully summarised matters in their written case, which we find at Volume 1, tab 6,
Thank you.
115. I don't propose to turn it up. And in Supplementary Volume 4, there's a short note from the appellants, tab 1, page 7, which sets out in a schedule the way in which the 1961 Act as enacted has changed via the 2011 Act.
Which page? You gave us a page number. I didn't hear
So,
it. Your page number. You're the appellants.
in the appellant's note, that's in Volume 4,
Thank you.
where behind tab 1 is a note, page 7, appellant's note on amendments. Turn the page to page 8 and 9. There we see a table or schedule which sets out the relationship between the sections of the 1961 Act 5 through to 9, which those are addressed by Clause 27 of the Neighbourhood Planning Bill. I propose to come to those second because they're second in time. And then what happens in terms of the 2011 Act is that we have sections 14 through to 17 replaced by a new section 14. And I don't propose to deal with that at any great length, but it probably is worthwhile to take up in that regard the authorities bundle, Legal Authorities Volume 1, where at tab 2, my lords will find the 1961 Act as amended.
Yep.
And it's worthwhile to highlight 3 or 4 points from section 14. Going to start by going to 14.1, which tells us what the purpose is. This section is about assessing the value of land in accordance with Rule 2 for the purpose of assessing compensation in respect of compulsory acquisition. It encapsulates, as I've sought to explain via the schedule, that which was previously in a number of sections, so that we can orientate ourselves in terms of hope value. That is now the prospect, which we find at 14.2b. So, in consequence of Rule 2, account may be taken 2b of the prospect on the assumptions set out in subsection 5. So there's hope value finding its way into this scheme. If I may, I would now like to go to the end of the section to explain just 2 other key features of the changes. We have a definition at subsection 6, page 410, of a launch date. So we now have a launch date, just to draw attention to that as being the date on which one has first notification. That's different to the situation we have in this case, where we have a valuation date which is founded in the general vesting date for the CPO. And so this process moves the time for consideration of value to rather earlier in the process. And as a matter of interest, but nothing else, the discussion which it was necessary to have about the extent of the KBP which had been built out would not have been such.
Yep.
2 other points, and there's a reason for taking them slightly out of order.
Yep.
Going back then to 5, subsection 5, there the assumptions are set out.
Yes.
And we find the cancellation assumption 5A.
Thank you.
That the scheme of the development is cancelled.
Yep.
And lastly this, if we can go to subsection 8,
Yes.
top of page 411.
Yep.
There we, because we've discussed matters of fact, if there is a dispute as to what is to be taken to be the scheme, then that's a question of fact for the upper tribunal. That's all I propose to say, unless I can help further on those changes. And I set out in the note the changes which are put forward in clause 27 of the Neighbourhood Planning Bill. So we have set out in the note at volume 4, tab 1, page 9, the scheme principle, the no scheme principle there set out and defined. And so what's happening in the Lords at the moment is perhaps piecemeal, perhaps stage-wise, but there are further changes afoot in the way in which compensation is assessed, and Localism Act dealing with assumptions now changes afoot in respect of disregards. They're summarised there for my Lords, along with at paragraph 6 of the note, what the Minister says the purpose is. And at page 11, lastly this, page 11, the penultimate paragraph, what the Minister says is that the intention is to replace sections 6 to 9 of the 1961 Act, which set out how the scheme is to be disregarded, and the proposed section 6A will maintain the fundamental principle that all increases or decreases in value caused by the scheme should be disregarded and list the assumptions to be made. Upper tribunal if there's a dispute. My Lord, that's the position.
So, in effect, I mean, we in the Law Commission, we proposed a sort of new scheme a new legislative scheme dealing with all these sort of no scheme world assumptions. And we're sort of getting there, are we now?
Well, my Lord, if one does the comparison, one sees both quite a lot of the words from that code and indeed quite a lot of the structure.
But I mean, so what's being done by Parliament is consistent with the proposals that we put forward in the Law Commission.
Yes, very much.
But as far as this case is concerned, is your submission to us that really what we say on this is not going to upset the apple cart, at least certainly if we're with you on your side?
That's absolutely right. Though what I would say is that it is of some relevance outside the scope of this case because of the significant number of CPO valuation issues which remain under the
old law.
Yeah.
Yeah. Yes, thank you.
Gideon, I'm sorry to be behind the curve, not for the first time or last. Could you look at the supplemental volume 4, pages 9 and 10, where the new proposed 6A no scheme principle is spelt out?
Yes.
6 and 7 assume that there's no prospect of the same scheme or any other project to meet the same or substantially the same need being carried out. No consideration, rule 4, of whether other projects would have been carried out if the scheme hadn't been commenced, etc. Now, what do you say? Do either of those alter the present position or not?
Substantially not, is the answer.
That's what I thought. All right, thank you very much.
I'm grateful.
Thank you very much. Thank you, Mr. Kimberley, and thank you, Mr. Kingston. Mr. Humphreys.
May it please your lordships. In this matter, the respondent has set out its case fairly fully in its written case. That, my lord, was because clearly in the limited time available, we were very keen to get across a number of what, in my respectful submission, are in some cases quite difficult concepts and draw together a number of authorities. Therefore, in these oral submissions, what I intend to do is emphasize and, where appropriate, explain certain of the points, and obviously try and give myself time to respond to your questions. A few preliminary points, though. First, it is important to bear in mind what in this case is the agreed issue. And the agreed issue is that one set out in the Statement of Facts and Issues at paragraph 38. You have it in Core Document Bundle 1 at page 45.
That's right.
That is the relationship, as it's been put there, between the planning provisions and the valuation disregards. And as a shorthand, you will have seen in my written case, on a number of occasions, I characterize the issue of is it permissible when applying the valuation disregards to revisit and revise the planning status of the land derived under the planning provisions. And Your Lordship asked what is the point of public interest. That, in my respectful submission, is the point of huge public interest to practitioners in this particular field.
So it's a sort of compartmentalisation issue almost.
My Lord, I will try and develop this, and it's one of the points that I develop in the written case, what I've called the two stages.
You said it's of enormous interest. Does it also arise under the new law? Then?
Yes.
It does.
Potentially. Because the new provisions have been revised in the way that my learned friend Mr. Kimblin has described to you, but that still doesn't resolve, whatever your lordships decide in this case, whether applying Section 6 as amended, one can reach back and change something under Section 14 to 17 as amended. So that issue is a very important one. Next point I make just as a preliminary point is the appellants have sought in certain regards to characterize our case as simply a case seeking to upset the planning judgment or the weight to be attached to certain planning issues by the upper tribunal. That, with respect, is to mischaracterize the issue. The point that we have tried to make, the point that I've tried to elaborate in the written case, is that that planning judgment and the weight, therefore, to be attached to certain issues has to be undertaken in the correct legal framework. And there's almost a sort of presupposition, never actually dealt with head-on by the appellants, where they say, well, when looking at the planning assumptions, one can apply the no scheme world rule. And I respectfully say, why? On what basis can one do that in the current state of the law? And you'll have seen that a lot of my submissions go to the fact that in relation to both Section 6 and Schedule 1 on the one hand and Point Gord as an adjunct, as an additional court-made principle on the other, don't permit one to apply a no-scheme world assumption when looking at planning assumptions. I'll come back to that and obviously develop that particular point. The third sort of preliminary point I make is this. Much of the appellant's printed case, indeed much of their case in the oral submissions made to you today, focuses on various reasons, you were given at various points lists of them, as reasons why the tribunal would quite properly regard there as being a high or higher prospect of planning permission being granted when one looks at the planning status under Section 14.3. So you were told, well, look, there was access via the nib, and look, there's residential development on the other side of the road, and this is a green field, and a number of points like that. My Lord, insofar as those were points that were made, those reasons, then there's no reason to believe that the upper tribunal did not take them into account in arriving at its 50% value. This case is not about the things they did take into account. This case is about the things they did not take into account, or the things to which they gave less weight, not the many things that you've been pointed to, where they did presumably apply what they thought was an appropriate level of weight. So this case is about the application of the law that caused the upper tribunal to disregard or give less weight, in certain cases, to certain planning matters. And those include the criteria in the policy that applied to the site, policy EC6, and to the planning history, especially the null refusal. And your lordships have indicated that you've obviously read the upper tribunal's decision carefully, but you will obviously be aware in paragraphs 94 through to 96 in particular, but then going on to 98, where they come to their 50-50 prospects. There are a series of places there, all under the overall heading of the disregards, where they're clearly applying Section 6 and Point Gord to give less weight, or in certain cases to disregard certain factors. And, as I hope is made clear from our written case, it is clear that in coming to a judgment at the end of those passages, in paragraph in paragraph 98, where they say they've given some extra hope value. In the light of all the things above, which are the no-scheme world, they've given some extra hope value of permission for residential development, and they put it at 50-50. It's clear that that extra hope value, is as a result of the application of the no-scheme world. And the fact that they have applied a no-scheme world rule in applying it, that is also apparent when one looks much later. I think it's not actually quoted in my written case, but it's very clear if one looks at paragraph 117 in the written decision, where they say, as we have said in our conclusions on planning and the law, we do think that there would have been a 50-50 chance of planning permission being obtained on the reference land in a no-scheme world. We think it realistic to assess the period of deferral as 5 years. So it's absolutely clear that the 50% judgment was a 50% judgment based on the no-scheme world. Now, if I turn to the next theme, the structure of our case, as you will have seen, we've tried to identify early in our written submissions what we've characterized as being three approaches: the first approach, second approach, and third approach. And it's easy to remember them because they're in chronological order of when they were first developed. So the first approach is the submissions that were made to the tribunal. The second approach is the tribunal decision. And the third approach, obviously, the Court of Appeal. And in the written submissions, in the bundle, pages 66 to 69, we've tried as best we can, in fairly neutral terms, to characterize those three before going on to deal with them in detail. It's fair to say that before the tribunal, both parties advocated in their submissions the first approach. And indeed, I note my learned friend's oral submissions to you, where he said, if I've understood it correctly, and I will stand corrected if I've got this wrong, that he says that the tribunal was adopting the first approach. Well, it seems to me clear that that is not the case. The tribunal adopted a different approach. It's right that it did, in the early part of its decision, seem to reflect the submissions that I had made, that there were planning assumptions to be considered and then valuation disregards. It made the point that the two were not to be, its word, elided. But it does seem that when applying the approach, it has come into error in the way that I've said it's very clear that it ultimately determined planning status by reference to a no-scheme universe, as it called it, which, as I have explained, is a stage 2, section 6 or point Gord principle and not a stage 1.
Are you submitting that there can be no overlap between the matters that are relevant at these stages?
My Lord, I would characterise it in this particular way. Before one values something, one has to know what one is valuing. And the thing that therefore has to happen, which is what I've called stage 1, is that the characteristics of the land have to be identified. What is the extent of the land? What is the interest that is being acquired? Is it a lease? What are the terms of the lease? What does the lease allow you to do if it's freehold? What then are its potentialities? And one of the potentialities of the land is the ability to use it for some other purpose, in other words, to develop it. And that's what is dealt with in sections 14 to 17. And those, what I've characterised as the planning status of the land. And I've, again, tried to use the language quite clearly. The planning status of the land could arrive from an actual planning permission, could arrive from planning assumptions that may be made under sections 15 and 16. It could arrive also from a hypothetical purchaser coming along and forming a judgment about the planning prospects.
That's the state I don't understand. Section 14 onwards deals with certain planning assumptions which you're required to make, and they're all beneficial to the owner. They're saying in certain circumstances, if there is a permission, you assume that. If there's a prospect of permission in certain cases, you assume such a permission. They're not dealing with hope value, and they're not dealing with negative planning factors.
No.
And indeed, they say specifically that the fact that you're not within one of these assumptions doesn't mean that you should assume there wouldn't be a planning permission.
No, section 4.
So fine, you get all that package of, if there are any planning permissions to be assumed, which in this case they weren't, then you put them under your belt. But then when you come on to the next stage of valuation, you seem to think that you can't have a regard to planning assumptions at all. You can't even have regard to hope value. And I don't see where you get that from.
No, on the contrary, one can very much have regard to hope value. Remember, one of the reasons why in this case the respondents formed the conclusion that on the facts, and I know we're not dealing in a sense with the valuation facts in quite that sense, but one of the reasons why we said on the facts there is no hope value here above existing use value is that this is backland. It has no highway access.
Yes, you said that.
And it would be necessary
and
to
you failed on that point.
purchase.
So, yeah.
Well, no, we succeeded on that point. That's part of the valuation. We said you would have to buy the...
Yes, you have to buy it, and that's why there's the discount and so on. But,
Correct.
But calling that planning status seems to be giving it a sort of name which simply doesn't appear in the statute or in the law. It's simply a question of valuation, whether there's hope value or there isn't hope.
No. Hope value is very definitely dealt with at the valuation stage. The first stage is not dealing with hope value. It's dealing with hope, the hope of a planning permission, or, as I've characterised it again in the submissions to avoid confusion in most cases, the prospect of planning permission.
Well,
therefore...
Is there anything in 14 to 17 which identifies or requires the tribunal to identify as a planning assumption hope, what you've been calling hope value?
No, not in terms.
14.2b isn't that, is it?
It's in the existing Act. It's section 14.3 that says that just because, in my shorthand, just because there are these various other assumptions doesn't mean that some other planning permission
14.3.
granted. Yes, tab 1 in the legal authorities bundle, and 14.3 says nothing, sorry, my lords, it's paragraph
2B.
It's 14.3 on page 390.
yes.
Nothing in these.
Nothing in these provisions shall be required as construed as requiring it to be assumed that planning permission would necessarily be refused for any development which is not development, which in accordance with those provisions, the granting of planning permission is to be assumed. Now, my lord, it's on that provision, which is almost a sort of a negative provision, that the entire basis of hope of a planning permission has been built.
Why that? I mean, why wouldn't you say that if you're valuing land, you take into account anything, including hope value, unless you're told you can't?
Well, the point that I'm making, in the first instance, one needs to understand what the hope is. The hope is a prospect of some planning permission.
It is.
And so first, under all these sections, you can see the section heading, Assumptions as to Planning Permission. Mm-hmm. The first one does is to look at what is there a hope of, what's the prospect of some planning permission, so that the hypothetical purchaser comes along, he says, have I got an actual planning permission? Yes or no, for whatever it is. Can I assume a planning permission under section 15 or section 16? Possibly. But he then asks himself, look, do I have a prospect of some other planning permission? And this is very much the issue that Lord Carnworth in the Court of Appeal in Spirose looked at, and we'll come on to Spirose in the House of Lords, but very much this issue of the basis on which one can look at the prospect of some planning permission coming forward. My essential submission on the two stages, therefore, is that one looks first to look at what this basket of planning permissions may be, an actual planning permission, an assumed planning permission under section 16, for example, perhaps some prospect of some other planning permission that it's thought would come about. And that forms part of what in Spirose, my Lord, Lord Newberry referred to as one of the characteristics of the land. That's one of the characteristics of the land that you then ask the valuer to say, right, with a piece of land, with this interest, this extent, everything else, and these potentialities as to how it can be developed, what value does it have? And if the prospect of planning permission, the hope of planning permission, gives rise to a positive value, that's hope value.
Yeah.
So, my lords, just coming back there to the three approaches. So the essential point there
I'm
is
still having some trouble with this. I mean, Section 14 is part of a package of measures which was introduced back in 1959 to try and get back to market value compensation.
Yes.
Following it being taken away by the Labour government in 1947.
Right.
If you forget about all that, go back to the common law, then it was very well established that one of the things you took into account in valuing land was obviously the potential for development.
Yes. And
that was true before you had any sort of planning controls. The advantage in a way of Melwood, as it seems to me, is it shows you how a common law jurisdiction, which hasn't been cluttered up with all this legislation, deals with the issues under the ordinary no-scheme principle. I mean, it was taken for granted that the prospect of planning permission in a no-scheme world was something you took into account as part of the valuation.
Yes.
It didn't get into two stages. It was just part of an exercise.
Yes. My lord, in a sense, Melwood, I would respectfully suggest, for a number of reasons, doesn't take things further forward. Firstly, obviously, Melwood, being a case that came to the Privy Council from Queensland, was very much decided within its own framework. And yes, that did include applying a no-scheme world. But we now know from Waters that the Point Gord principle is to be applied, in most cases, as an adjunct to Section 6. That clearly wasn't the case in Melwood. And as Lord Nichols in Waters made very clear, it fills to what he described as two lacuna, and those would be very familiar to your lordships. Secondly, of course, Melrose was long before Spirose, which made it very clear that Point Gord goes to value, doesn't go to the characteristics of the...
You're going to come to that, are you?
I'll come to that. But thirdly, of course, Melrose was well before and therefore didn't need to rely on Fletcher Estates and the introduction of what then became the cancellation assumption. So let's take the facts of Melrose and drop them into Melwood, sorry. I apologise for saying Melrose, my lord.
There's the Spirewood, yep.
Spirose, yes, I'm conflating the two, or eliding, I suppose I could say.
Yeah.
Melwood, if one drops it into the correct approach, as I said, would be looked at in this way. There were 37 acres of land, and the Commissioner for Main Roads had a proposal for a road through the middle. Looked at on the planning provisions first, as now apply, one would say, right, we must cancel that provision for the road. So the road is cancelled, and you then ask yourself, well, what planning permission, what prospects under Section 14.3 would there be of planning permission? And as the equivalent of the upper tribunal in Queensland made clear, there would be a very high expectation of planning permission. That would then be carried to the valuation stage. One would say, right, I have very high expectation. It would be expected that planning permission would be granted if the road had been cancelled. But, of course, I have a road going through the middle of my planning permission. But applying Section 6 with Point Gord filling the first lacuna, I have to disregard the adverse effect of that road. In other words, I disregard the Commissioner for Main Roads bringing that road through, and therefore my planning permission can be valued without the road. And so there's no need, in the light of the modern case law in Melrose and on the facts of Melrose, to go back to importing a no-scheme rule at the planning status stage. It's just completely unnecessary. It's been overtaken by events.
I mean, you're submitting, as I understand it, that you cannot assess the planning status on the assumptions which are required of you by the disregards. Is that in a nutshell what you're alleging?
Yes, it's important to understand, and I hope this is developed in my written submissions sufficiently, what the disregards are. The disregards don't say anything about a no-scheme world. That is simply a piece of language.
Shorthand, yeah.
It was called jargon to create this. What Section 6 tells you is that you have to disregard the development or the carrying out of development or the prospect of development, in effect, by the acquiring authority.
On the adjacent land.
On the adjacent land.
Yeah.
When you apply Point Gord to fill the first lacuna that Lord Nichols identified, which is Section 6 doesn't seem to deal with the land itself, and as Lord Nichols said in his pointers, you would apply it by analogy. I think it was pointer 4. You would say, well, look, I apply Point Gord, therefore, to disregard the development or the prospect of development by the acquiring authority on the land itself. So it seems to me, going back to Melwood, and obviously we've taken things slightly out of order, Melwood would be decided in the same way on the construct which I say is correct, as it was in the Privy Council in relation to the decision in Queensland, which was obviously in a very different legislative but also judicial period in terms of decided cases.
I'm awfully sorry, Mr. Humphreys, but I'm still struggling with 14.3.
Yes.
Why is it that you say that 14.3 firmly places the relevance of possible hope value in what you have called the first stage?
My Lord,
What's
when
it
you
got to do
look
with
at
it?
the scheme...
What's it saying? If you would have made an assumption of planning permission under 15 to 17, you're not to take anything in 15 to 17 as requiring you to assume that the permission would be refused.
Yes.
Right.
But that assumption, my Lord, you put your finger on something which for practitioners in this area has long been understood and long been used, but as you can see is not satisfactory. The whole law, as you will see it in this case and indeed all other cases in the tribunal relating to hope value, always goes back to that provision. There is no other
why,
provision.
with respect.
No, I don't understand why.
I mean, and we did discuss this I think, in the Law Commission report. I mean, the whole point of Section 14 and these assumptions, they're positive assumptions in favour of the owner.
Yes.
They're saying you're entitled to make these assumptions.
Yes.
And you're entitled to assume that if there's an actual permission, you're entitled to assume that. Even if you wouldn't have got in the no-scheme world, you're nonetheless entitled to have that. So it's things you can put under your belt. And then 14.3 is saying, well, that's not in any way to prejudice any assumptions you would have made apart from these sections. And that's why you're left with the Point-Gore principle as it was, and in which valuation includes hope value, and if there is any. There's nothing in 14.3 which stops you taking account of hope value at the second stage.
My Lord, I think the point is this, that as Spiro has made very clear, Point-Gore goes to value and not the characteristics of the land. And in my submission...
That assumes that these are hermetically sealed compartments, and that's the whole question.
My Lord, they're not hermetically sealed, but for valuers, as a matter of practice in the tribunal, and I know obviously your lordships must sort of interpret the law as you find it, but what actually happens in the tribunal, as indeed happened in this case, is that the planning expert comes along and gives evidence about planning prospects, whether there would have been planning permission under Section 15, whether there was actual planning permission, etc., like that, stops. The valuer then picks that up and then says, right, with that land, with that basket of attributes, including how it can be developed, what value do I place on it, disregarding the fact, of course, of any increase in value due to the actual development that the acquiring authority was going to undertake. Now, to allow a reach across between these two things creates real difficulties in that it would require a valuer to start saying, well, this particular aspect of the planning assumption or planning permission may affect value and therefore I will adjust the planning permission accordingly. Or if you ask the planner to do it, he would say, well, which bit of these planning permissions affects value for me to do it? It makes it very difficult. It's not that it's hermetically sealed, but it's that there is a natural progression between first identifying the land, the interest in the land, the planning permissions, the planning prospects for that land, for anything else,
The trouble
then
is,
valuing it.
where you say the Point-Gore principle and disregard and non-scheme world assumptions come in at the first or the second stage.
The second stage.
That's where you hit problems, because if the first stage involves identifying what you're valuing and the second stage simply involves valuing it, then I see your point. But if you say the first stage involves identifying what you're valuing and the second stage involves tweaking what the first stage involves, then inevitably you're going to have to go back to the first stage and say, "Hoi, this is what you said we've got to value.
Yes.
We're making a different assumption. What effect does this have on what you say we have to value?"
And that's exactly
why it seems to me you can't have the two.
Yes, well,
hermetically
that's
sealed.
exactly why my proposition is the first of the two alternatives you gave me, and I'm arguing against the second. I'm arguing that you decide first what you value, including its planning, its development potential, and then you value it. The point I was putting to you is that to do what you then put to me of reaching backwards and forwards across the two creates not just, I say, legal problems, but frankly, practical problems for...
So, but I thought you said the point guard principle, the assumption that you adjust for non-scheme, is at the second stage.
Point guard is at the second stage.
But then I maintain the point that you can't. It has to go back to the first stage because you're changing the assumptions you're valuing on. What you've been told at the first stage.
My lord, no. My whole point is that point guard does not allow you to do that.
Why? Because the whole process you've described by reference to these practical considerations is the breakdown into stages, whether hermetically sealed or not. These are not rules of law. They're simply techniques for analyzing fact. And if you arrive at a situation halfway through your analysis of the facts where you need to revise some earlier conclusion about the facts, that's absolutely a bog standard issue in all fact-finding, not just in the planning world, but everywhere. You always have to stand back at the end of the exercise and say, well, does this hang together? And do I need to revisit earlier stages of my analysis in the light of conclusions I've reached subsequently?
Well, my lord, that may be so in certain circumstances, but we would then be left with the result that one would start by looking at planning prospects on the cancellation assumption and then go to value the land and say, well, actually, I'm now allowed to value on quite a different assumption, a no-scheme world or no-scheme universe assumption. And my submission in this case is that when one looks at Fletcher Estates, which first of all introduces the concept of the cancellation assumption as one of the part of the section 14 to 17 suite of provisions, one then looks at the upper tribunal case in Newell, which my respectful submission is insightful into these matters. It takes the cancellation assumption and then applies it to section 16, because the wording in section 16.7 is very similar to that in section 17, and then says, look, section 14.3, which is the only provision we have about the prospect of planning permission, should be treated in a similar way. Indeed, in his Court of Appeal judgment in Spiros, Carnworth himself made the point that the legislative intent was clearly to assimilate these different provisions, and he was talking there about section 16 and section 14.3. He was using it, in fairness, in a slightly different context. But taking that principle, that clearly the legislative intent is to assimilate, one would apply the cancellation assumption, therefore, to section 14.3, and that allows you then to look at what planning permission would be granted. Now, on that point, of course, the appellants don't disagree with us. The appellants have made very clear, both in their written and oral submissions, that one doesn't cancel the entire scheme under the cancellation assumption. They accept that you cancel the scheme on the reference land unless, looking back at Newell, where it was said there could be examples on linear schemes, so a road, a railway, tunnel, pipeline, where it doesn't make sense to cancel a little bit of it and it to exist either side. You would cancel the whole lot. that if you then, the appellants themselves accept that you only cancel the bit on the reference land, that then gives you your planning prospects. My submission on these points is to then say it is not then appropriate, having come to a conclusion on what the planning prospects are, on the cancellation assumption, it's not then appropriate to change the assumption to a no-scheme world assumption, which is shorthand for what I've called the valuation disregards, which is disregarding the development or the prospect of development, and by analogy, Point Gorge should be looked at in the same way, disregarding development or the prospect of development. There's no justification for just simply saying, well, now we'll go back to planning and imagine that the scheme had never existed.
So the question that I was half framing was, what's the principled reason why the disregards cannot apply to the question of hope value? And your answer is it because it's inconsistent with the framing of the cancellation assumption?
It would be inconsistent with that, but in my written case, I've also set out, I hope in a number of places, why it would be inappropriate to... So I set out from page 90 onwards, well, from...
Paragraph.
I'm just finding the
Thank you.
paragraph, my lord.
Of course.
Yes, from page 96, paragraph 105, I say stage 2 cannot be used to revisit and revise stage 1.
Well, yes, I know, but I'm trying to get at is why not?
But that's
and the reason you say, I think, what you were saying just now is that it would be inconsistent with the way the cancellation assumption is framed.
Yes, because the cancellation assumption...
First one thing and then something
Correct.
inconsistent.
That would be, I would say, respectfully suggest, part of it.
Yeah.
And you can see at paragraph 106, I identify there a number of propositions. First is to look at section 6 and schedule 1 itself to see if that allows one to go back to the planning stage and invent a no-scheme world for planning purposes. Second point I look at is Point Gorge and what was said about that, particularly in Spiros. And then C and D are points really which go to the fact that it may be, and this is probably a case, where the prospects of the land being developed or getting planning permission are actually reduced by planning policy. And as you'll have heard, again, it's common ground between us that planning policy in this case is not part of the scheme on any basis and is not to be disregarded.
But if the object of the exercise is to pay the landowner what the land is worth apart from the scheme, why not?
Because that's what stage 1 would do. At stage 1, one does cancel the scheme. One assumes that the scheme is cancelled. You do cancel the scheme. The point is that you don't cancel everything else in the world. You cancel the scheme on the reference land, or if it's a linear project, you cancel the whole scheme. But planning policy and everything else continues, and therefore you ask yourself on that basis, right, what are the prospects of planning permission as against the planning policies that existed? And this, going back to the upper tribunal's decision and those particular paragraphs I drew your attention to, this is where we say the upper tribunal went wrong, because paragraph 94, 95, 96 through to 98.
Right.
That what the from 94, in arguing that there would have been little prospect of permission for residential development taking access from Buckley Hill Lane, the acquiring authority puts a lot of weight on the NAL planning application in section 17. Just to explain the significance of NAL, NAL was an actual planning application 3 years before the valuation date against the actual policy that existed for almost the identical form of residential development with access through the nib to Buckley Hill Lane, and it was refused for a variety of reasons.
Right.
Our case was, for a hypothetical purchaser, or the upper tribunal standing in the feet of the hypothetical purchaser, that would be extremely material to know what that was, that the actual authority had refused permission for this development. Of course, what the tribunal then did was to say, but we now have to create a no-scheme universe, and therefore we can disregard the NAL.
Well, are they entitled to say, as they do in 96, that the reasons for the refusal was you can't have that because it'll get in the way of Kingsway Business Park?
No, because if you look at the terms of the refusal, what it does is it is a refusal on the criteria in the policy. And the criteria in the policy were development on this site, amongst other things, development on this site has to take access from new spine roads, from
Well, that's a question of fact for the tribunal, isn't it?
But it's also
But the new
assumed
spine,
that
yes, the new
it's
spine.
only going to be that it's going to be more than a residential scheme. It's going to be a business park.
Yes. It would be a matter for the tribunal if they were approaching it in the right way. And if they had applied the cancellation assumption, they would have said...
Well, is that a question of construction of the... Is your point? Does it depend upon the true construction of the statute or what?
My point depends on proper construction of section 16, which was the analogous section, which was also considered in this case, and the fact that the cancellation assumption in relation to that would also apply to the no-scheme world. That's what the upper tribunal said in Newell, and therefore you cancel the scheme, but you don't cancel the planning permission. So
Only cancel, your point is that because the cancellation assumption applies only to the reference land, and you're required to do that,
Yes.
you can't then undo that reasoning when you get to the valuation
Correct.
stage. That's what it's all about, isn't it?
correct, because at that stage, if you're only cancelling the scheme on the reference land, the rest of the business park goes ahead, the policies are still there. You ask yourself, in those circumstances, why would the planning authority, which is of course not the acquiring authority, I don't appear for the planning authority, that's Rochdale, why would the planning authority, which wanted a comprehensive business park development with access through a spine road to a new spur to the motorway, suddenly turn around and say, well, look, we'll just disregard or give very little weight to all of our policy criteria here, and we'll allow you planning permission with an independent access through the nib to Buckley Hill Lane. And you ask yourself, well, what did they actually do when they were actually faced with that in the NAL refusal, which of course was predated the confirmation of the compulsory purchase order, so there was no confirmed Kingsway Business Park scheme at that date. They were actually faced with that question, and they refused.
Well, yes, but I mean, if one looks at paragraphs 94 to 97, there is, because you're making an artificial assumption, they are entitled, you accept, I take it, the upper tribunal, to consider the force of the point that planning permission was refused as described in paragraph 94, yes? They are entitled to consider the force of that in light of the artificial assumption.
They are
Yes?
entitled, of course, to consider it as long as they're doing so on the proper assumption.
Now, if we go through those paragraphs, which is the sentence or sentences which shows that they've gone wrong in principle when they consider that point?
Well, 96 starts by saying, for those reasons, which is talking about the various reasons above, it does not seem to us that we should attach much weight to the refusals of the NAL application.
Then they proceed to explain it, I think. But where is it that they've gone wrong?
Yes. And in the fourth line in that paragraph, in a universe where there is no such scheme, while accepting that planning authority would not wish to do anything to impede a substitute plan, those reasons for refusal would have had to have been very carefully considered and might carry much less weight. So again, you can see they're considering this now not on a cancellation assumption. They're creating a universe where there is no scheme, and that was the whole point. And they go through that.
Sorry, I mean, you seem to be eliding Section 16 and Section 6. I mean, Section 6:16 requires you to assume that the scheme is cancelled on the relevant land, which is the reference land, but not that it's cancelled anywhere else. Section 6 requires you to go beyond that and disregard any diminution due to the prospect development on the non-reference land.
Yes.
So they're completely different points. So it's not surprising that the tribunal are dealing with them in a different way.
Well, absolutely, they are, and that's exactly the point, that what the tribunal was doing here was applying the Section 6 point, the disregards, to go back to...
Yes, well, we have that point. I mean, you say that for some reason they're not allowed to do that because you've dealt with planning status before. But if you're wrong on that, then what they were doing is perfectly understandable.
Well, if they are allowed to do that, one would need to understand, obviously, why they were allowed.
Well, I mean, Melwood is a perfect example of that being done, admittedly not under Section 6, but certainly the tribunal are here treating Section 6 as, in effect, an embodiment of the Point Gold principle, which is consistent with Waters.
But in my respectful submission, Melwood is quite clearly inconsistent with Spiro's in the House of Lords.
Well, I mean, if you're going to make that submission, it needs to be made good, because Lord Collins refers to Melwood, as far as I can see, without any suggestion that it's wrong.
Well, I think that is one of the circumstances. He does refer to it at one or two places. I don't think he refers to it as being right.
I mean, if you're going to get to Spiro's, I think we'd need to look at it, because you do rely on a passage from my Lord Newburgh. It's rather important to see what you're actually saying about Spiro.
Yes, certainly. But, my Lord, so coming back to the theme, firstly, we say that it's quite clear, and again, one looks at Newell on this point, that when looking at the prospects of planning permission, one would apply again the cancellation assumption. Mm-hmm. In this particular case, it is agreed between the parties that one would apply the cancellation assumption in exactly the way that I have said. The appellants, as they said in their oral submissions, accept that you don't cancel planning policy or any of those particular matters. Where we differ is simply this point of whether Section 6 or Point Gold allow one to alter that, whether they allow one to impose a no-scheme assessment, which is very clearly what the tribunal do in sections 94 to 97. And as I said, that's made abundantly clear also in paragraph 117. Now, my Lords, I notice it's now 2 minutes.
You're saying this is a convenient moment?
I'm saying, my Lord, it's a convenient moment.
So be it. We'll resume again at 2 o'clock then. Thank you very much indeed. Court's now adjourned.